Good morning friends, this is my 66th video in continuation to the Cantonment Bill 2020 and its various sections which are going to affect us if they are finally passed as an act. Now coming to section 82 where the building erection and the basic subject where we have a lot of problems. Now notice for erection. If any building is erected, re-erected with the meaning of section 207, the owner shall give notice thereafter to the CEO within 30 days in completion and of the occupation of the building. Any person failing to give the notice required by subsection 1 shall be punishable with a fine which may extend to 20,000 rupees or 10 times the amount of tax payable of the said building is erected or re-erected as the case may be, in respect to period of 3 months which could be even increased or be greater. So what are we doing? Earlier we had 244 which said 10,000, 1 lakh, today we are saying 20,000 or 10 times to the tax what we pay. Today with the COVID and the economy condition of the people in these cantonments is actually going down. Because we don't have any resources. Our buildings, our properties are so deflated. Our per capita income, if you just read the yesterday's newspaper, has even gone down below Bangladesh. And the government says that we are in a position to pay 10,000, 1 lakh or 20,000 or 10 times the tax for a building erection which has not been completed or which has not been informed in 3 months. This section really does not match what Mr. Bose has been saying in his committee report in 2019 under section 144, where the present section is 139. So what are we, again we are looking for permissions, again we are going back to the same old that the CEO will have the right and whether he allows us for permission, and then in 205 section of the Cantonment Act, the bill proposed 2020, the zones have to be made. Actually, our buildings are being depreciated when any kind of compensation or assumption areas are come. We are generally subjected to, we are 100 years old building. But when it comes to the annual rateable value, we are charged for the rent which is of the present. Why this increase and why that decrease then? So these two things cannot go side by side. So wake up. So section 72 and 139 of this Cantonment Bill to 2020 should be re-looked into. Now we have section 86, burden of proof while claiming remission of fund. Now again, what is this remission? Remission is of the tax. There needs to be a time limit fixed in this. And it should not be undertaken retrospectively as stated in the judgment of Madras High Court in 1929. Other residents, we all face that uphill task that the tax superintendent should be made liable for all wrongs being done. He doesn't receive our letters independently. Why? Under section 83, 84, 85, he should be made to answer our objections within 7 days. He should be made to ask to make a building plan when he makes an inspection. So these are so many things which are left open in this act also. So where is that democratization going? I don't think so. Again, like house tax, like building, again that 244 is not being removed. Again this is asking for a punishment of 20,000 plus 10 times. I don't think so. This bill is actually in favor of the cantonment and it is more towards the municipalization. Friends, please call up your friends, call up the new association, old association, primitive association, defunct association. Wake up, create those local associations in your cantonments. I know there are many cantonments have beautiful associations and are running very well. Let them all get together and let's work together. Thank you. Good day.